Call the meeting to order. Begin with the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Have a call on the roll, please.
Councilperson Thacker.
Here.
Councilperson Wager.
Here.
Councilperson Thies.
Here.
Councilperson Norris.
Here.
Councilperson Wilson.
Here.
Councilperson Thompson.
Here.
And Councilperson Loudermilk.
Here. Thank you. Next, we have before us the corrections to the journal of preceding meetings. First up, we have the April 5th, 2022 Sunshine Meeting. Please review those meeting minutes for accuracy. And note any changes or corrections that need to be made at this time. If there are no corrections, I would entertain a motion to approve as presented.
So moved.
Second.
Motion on the floor to approve by Councilman Thompson, second by Councilman Norris. Any questions or comments?
The only comment I'd like to make is I will abstain as I was not present at that meeting.
Thank you. Any additional questions or comments? Having none, I ask for roll call vote, please.
Councilperson Thacker.
Abstain.
Councilperson Wager.
Aye.
Councilperson Thies.
Aye.
Councilperson Norris.
Aye.
Councilperson Wilson. Aye. Councilperson Thompson.
Aye.
And Councilperson Loudermilk.
Aye. Motion carries. Next, you have before you the April 12th, 2022 meeting minutes for the regular session meeting. Again, please review those meeting minutes for accuracy and state if any corrections need to be made to what we have noted before us. Everything appears to be accurate. No corrections need to be made. I would entertain at this time a motion to approve as presented.
Move.
Second.
Motion to approve by Councilman Thacker, second by Councilman Thompson. Any questions or comments? Roll call vote, please.
Councilperson Thacker.
Aye.
Councilperson Wager.
Aye.
Councilperson Thies.
Aye.
Councilperson Norris.
Aye.
Councilperson Wilson. Aye. Councilperson Thompson.
Aye.
Councilperson Loudermilk.
Aye. Motion carries. Thank you. We'll now move on to public comment. For this meeting, council rules dictate that public comment is limited to items not on tonight's agenda. So if there's anyone in the audience that'd like to speak about something that is not on tonight's agenda, now would be the time to do that. I'd ask you to approach the podium and state your name and address for the record.
Jared Rankin, 3893 East Sandalwood Avenue. I just kind of want to give you guys a little bit of follow-up on the Lucas device. 10 of the 13 devices have been delivered, so we're looking that those will be implemented by the end of the week. Just want to, again, reiterate my thanks to the council, especially to Calissa. I don't know if you've seen her office or lack thereof. Now it's been overrun by boxes, but to Calissa and everybody that was involved in that, very appreciative. So hopefully by Friday, and I plan on sending an email at least to Councilperson Thompson and Loudermilk about maybe a group training here, and I think I'd be more than welcome to have you guys here to kind of witness the magic. So that's all.
Thank you.
Thank you. Is there anyone else? Moving on, communications from elected officials, other officials, or agencies of the county. Again, this is limited to non-agenda items.
Hi, thank you, Council. Kevin Gardner, County Assessor. The first thing I'd like to say is basically just a public announcement. Form 11s did go out on April 29th. If you haven't received one by now, it's probably because we've got a bad address. So if you want one, you can call into the office. We can either mail you another one, or we can do a email to you to get it to you. Otherwise, we have gotten about 200 back. We've tried to remail some of them, finding better addresses, but if we don't have an address, we can't get it to you. My second thing is basically a question, and I'm not sure if this is the time to ask it, but I'm going to go ahead anyway. We had the study that was done by Baker Tilly, the compensation study, and based on the schedule that I have and the plan that I thought was initially set in place was sometime mid-April, something was going to be presented to department heads and the council to see if anything needed adjusted. And then at some point, mid-May, is when the council was going to look at it and try and determine what they wanted to do. Is there any update? Because I haven't seen anything.
I think that was slightly different, was it not? Melissa pushed back maybe a month or two?
Well, they had, maybe it was April and May earlier, but we started later than what they originally proposed. And the new dates they gave was May and June, but we have not received anything back yet with numbers.
Okay, thank you.
The last I knew, Kevin, the finished product was supposed to be sometime in June. That's
Okay.
my understanding,
Okay,
for us
Thank
to,
you.
as a council to review. Thank you. Anyone else? Moving on, reports from committees. There are none. Resolutions and ordinances other than appropriations. First up, we have ROC 2022-20, Resolution 2022-05, Treasurer, Adopt Investment Policy. We were presented with this last week. Mr. Modisett was present and spoke about it, and informed us it was a pretty standardized form that they're using. It was a kind of a basic template that is being used here. It's nothing extravagant, nothing out of the ordinary. We've had these plans in place in the past. We just haven't for the last couple of years, so that's why they're moving towards doing so now. Any questions or comments from council? Councilman Thompson?
I've got a question for Terry. Let me see, paragraph 5, the expiration date.
Yes.
The policy expires and has an expiration date of, on here it says exactly 4 years. Does it make more sense to change that to 12/31/24?
The statute requires that,
It
unfortunately.
requires 4
Yes,
years?
it actually says 4 years in the statute.
Okay.
That's the reason it seemed kind of wondering why you would have it like that, but the statute actually says that.
4 years, okay. All right.
Any other questions or comments from council? If there are none, I entertain a motion at this time.
So
Motion
moved.
to approve. Second.
Motion on the floor by Councilman Thompson to approve, second by Councilman Wilson. Comments from council? Having none, I'd ask for roll call vote, please.
Councilperson Thacker,
Aye.
Councilperson Weger,
Aye.
Councilperson Thies,
Aye.
Councilperson Norris,
Aye.
Councilperson Wilson,
Aye.
Councilperson Thompson,
Aye.
Councilperson Loudermilk.
Aye. Motion carries. Thank you. Now have before us ROC 20.2-21, public safety lit, options for distribution to units for distribution in 2023. Spoke about this last week also. You should have before you your packets on page 6, a table which outlines the potential distribution combinations for each unit. This will be for 2023, as we spoke about last week. This is based upon 2021 run and levy numbers. Historically, we've incorporated a 65-35 split, 65% run ratio to 35% levy. As you can see, that is highlighted on the table you have before you. Any questions or comments about that, the process? As I stated last week, the fire districts, fire departments have been satisfied with this distribution. Is there any desire to look at something else? And if not, I would entertain a motion for the 65-35 distribution ratio. Councilman Thacker?
I make a motion that we give the 65-35
Second.
distribution.
So motion on the floor by Councilman Thacker, second by Councilman Wilson. Motion is to approve the 65-35 distribution combination. Any questions or comments? Having none, I'd ask for roll call vote, please.
Councilperson Thacker.
Aye.
Councilperson Weger.
Aye.
Councilperson Dees.
Aye.
Councilperson Norris.
Aye.
Councilperson Wilson. Aye. Councilperson Thompson.
Aye.
Councilperson Loudermilk.
Aye. Motion carries. Thank you. Now have before us ROC 2022-15, Resolution 2022-06, Commissioners, resolution expressing interest in the purchase of a non-exclusive surface easement known as the Riley Spur. Resolution is on page 7. Any questions or comments about the resolution itself? Councilman Wilson?
I still feel that there are too many unanswered questions. You go ahead, please. I'm not comfortable with it yet.
Councilman Thacker?
So this has been an interesting project, and I've got the most feedback from this since I've been on council, and I've tried to acknowledge everybody that I've gotten those feedback from, and I respect everybody's opinions, and we've listened to some really good discussions, and I have talked with the attorneys and with the latest information they've given us, and I feel comfortable with the attorney's opinions. I've talked to Mr. Modisette, and I've talked to Mr. Effner. And, you know, I think it's going to be, I think we're going to make about half the people happy and about half the people mad, no matter what we do on this. And when we take these positions, we have to be willing to do what we think is the best. And so I'm ready to move forward on this and take a vote on it and see where we land. And I do appreciate everybody's, the commissioners and the attorneys and everybody that's involved on this process.
I have one more comment before we do.
Councilman Wilson?
We had a pretty resounding vote last week on the school corporation referendum. 2.5, possibly to 1, voted no for it. And that, to me, speaks volumes, because it seems to me that the people of this county don't appreciate excessive spending at this point in time. With inflation right on our heels, I think we're better off with a surplus until we see how everything shakes out. And this, we have, thanks to Adam Grossman, we have numerous parks and trails in this county right now. And I think that this is a frivolous expense right now. And actually, the people in my district, the people that I've talked to, about 200 people, and at least 165 of them said absolutely not. We do not want our tax money spent on this trail. We see no benefit to it for us. They see no benefit for 85 to 90% of the people, benefiting 10 to 15% of the people, or paying for 10 to 15% of the people who would probably use this. This is what I'm getting from the people that I represent, and it is their money, so I have to vote the way they want me to vote.
Councilwoman Fees?
I have concern about comparing the two, mainly because, and obviously I work very close with the schools, and I also work in this role, and the no's came for a variety of reasons. Yes, the fees were a big part of it, but there were also no's who preferred to do all brand new schools. There were some no's that felt like we should do a different amount. There were no's that wanted a mega school, and different aspects. So I think regardless, and looking at things as we make our decision, and looking at research I've done and economic development opportunities, and also, again, getting responses as well, then, that's where we need to look at it. I don't think we can compare the two. It's very different amounts, and this would not raise taxes specifically, whereas the school corporation one was. So I just wanted to clarify that part on it, and I was on numerous studies with that as well directly.
Thank you.
We also need to address the fact that there is a lawsuit pending on this with some of the landowners that are adjacent directly to the trail. I know that not all of them are included in this lawsuit, but there is one lawsuit that is unsettled yet. And then, as I understand it, there could potentially be another lawsuit filed soon by some property owners that feel that this easement should go back to them revert back to them as the 100-year lease or whatever the easement was has expired, and it is some of the verbiage. I mean, I understand that each attorney has their own slant on things, which is typical, but it needs to go to an actual judge to determine. We shouldn't be the ones to determine whether it should or shouldn't go back to the landowners. And as I understand that there's going to be possibly another lawsuit, and I, for one, don't want to be a party to another lawsuit, so I can't support this.
Thank you. Councilwoman Wager, did you have anything? Councilman Norris?
Mr. Ketchum?
Councilman Thompson?
I guess my question would be, where do we stand in your opinion, on the lawsuits?
I've not seen the actual lawsuits. I've seen a couple documents relating to the lawsuits, I think, I hesitate to give an opinion on that without knowing exactly what it is. I would say that to the extent that abandonment is an issue, I've had to do some quick research today because I haven't had documents before, so I can't say I've done an in-depth amount of research on any of this. But in regard to abandonment issue, I did find a United States Code statute which would indicate that for purposes of rails to trails, it would not be considered an abandonment. Okay, so I think that sort of resolves the question of the easement at this point in time. You know, now I don't know exactly what their leases look, or what their easements look like, or the granted easements look like. You know, whether it's per term of years, that might have an effect. I did see one, I think, that was provided, that was, I think the period was for the period of use of the railway. And this federal statute would seem to say that, well, if you're going to do a rails to trails project, that would not be considered an abandonment. So in that regard, I don't see a problem. Okay? You know, I have looked at the lease today. I can't say that it's one-sided lease. You know, to be honest with you, it's fair to the railroad. That may be the way it needs to be. You know, it does seem to be a unique opportunity, and it's the governing board of the railroads seem to specify things that need to be in the lease. I suppose in regard to that, you know, I do have a couple of concerns about it. One being that except for gross negligence or willful misconduct, the county basically agrees to accept liability and hold harmless the sellers from all liability, including attorney fees in regard to any lawsuits against any of the parties as a result of the sale of the easement to the county or as a result of failure of title. So basically the railroad is not warranting title, and I guess that's one concern. Another concern is that, you know, unless it's discovered for inspection prior to closing, the county assumes liability in regard to environmental conditions. So I don't know what the county's done, and maybe the commissioners have sought to have that inspected or will. You know, I think that would probably be advisable, because otherwise you're assuming the liability. I guess as far as the agreement itself goes, a couple things I would probably think would be good on behalf of the county is that, one, the seller should warrant title and should also accept liability for any existing claims or lawsuits. And I talking to Terry, I think perhaps there's at least been some verbal confirmation that they would do that, but I don't know where they're willing to put it in the agreement.
So are those things that-
But as far as being able to do the project, from what I can see, and again, I've just had the chance to look at this today and not had a chance to do any case research, but it appears to me that it can be done.
My comment on that. Oh, I'm sorry, you have the floor.
No, go ahead. Not yet.
There is a federal lawsuit filed out of Florida that you may or may not be aware of, that pertains to this. It's still ongoing. People that are suing, saying that the rails to trails shouldn't affect their ownership of the easement and the property. It's inexcusable, as far as I'm concerned, for our attorney to just be getting this information so that he has to, at the last second, try to put together some information for us. That's unacceptable and inexcusable. And then add to that, I called this Reed Ripley from the Stewart Ward McCulley today, or yesterday, I guess, and he said that he wasn't really at liberty to talk to me in depth on this, but the one thing that he said he could and would tell me, and that he would highly advise, is that we make sure that the commissioners are very sure about what they're signing in this lease. Just be very, very sure, because he didn't feel that it was fair to the county. And that sounds really ominous to me, and for you just to be saying the things that you found in it, I don't feel comfortable with this deal at all, not even a little bit. I mean, I am for trails. I like trails. This deal has been mishandled all the way along, and I do not agree with it.
Councilman Thacker?
Last thing that when I talked to Mr. Mattis about it, the letter that we got from the attorney that is talking about this litigation, they state in their own letter that the Surface Transportation Board has the exclusive jurisdiction, and it preempts all federal and state law. So that's why I have the comfort level that I feel like we can take action. Not telling anybody how to vote, but I think the part that we have is we're just the financial part, whether we're going to fund this or not. And how the commissioners handle the lease and how the commissioners handle what they're doing with the trail is that's the commissioners. We're the fiduciary. And so that's why, like I said, is I have done some reading on this and I've tried to respond to people, and I respect that people have their concerns, and I don't try to convince them otherwise. But that was the thing that, in talking to Mr. Modisette, was the comforting part for me, because I had questions early on too. And so I had questions enough that I took and I traversed the whole trail because I wanted to make sure there wasn't something out there that we weren't seeing. And so, I mean, I think that's due diligence is to do that and then feel comfortable that we're working with it, with the commissioners on this. And so I try to play nice. I don't always play nice, but I'm being supportive of the commissioners on this, and we'll try to move forward. And however the vote goes tonight, I just have one vote.
I want to reiterate what Bob said. We're taking on the liability. And there's a possibility that the landowners are going to sue the county over this if the lawsuit is found that they should have had the property reverted back to them. I don't want to be party to another lawsuit, and I think it can be avoided by putting this at the very least on hold. And because one of the stipulations said that the June 9th date could be negotiated, it could be extended, so that we have a little bit more time to evaluate or to allow the lawsuit that is pending to settle first. I don't understand the big rush to get this done.
Mr. Hefner, you spoke something about the seller should warranty the title of
Yes.
inspection.
I mean, I would recommend that.
At
Well,
this
I
point, they're
think
not.
they should, I guess at very least, I think the seller should warrant title to the easement to make sure that we're getting what, the agreement says we're getting. And also accept liability for any existing claims and lawsuits would be my major two things. And I'd also advise, I think I also think it'd be a good idea to do the relevant inspections in regard to environmental conditions, because I have no idea what liability may be out there for that. Maybe none.
So, if the council move forward tonight and approve this resolution we have before us, would that close the door for any opportunity to add that language in later?
Well, basically what you're doing is giving the commissioners the authority to proceed with this. So I guess it'd be up to the commissioners to I think, and you'd have to ask them, I don't know what leeway they have to negotiate, but I would say at this point in time, it's my understanding nothing's been signed, so anything can be negotiated. Now, whether or not you know, the railroad company is amenable to doing any further negotiation. It's my understanding they probably aren't too flexible. Is that accurate?
According,
If I may, Council, President, members of council, Larry Robbins, County Engineer. Some of the things are covered already in the agreement. Section 13.5 says, if environmental contamination of the easement is revealed to studies and tests conducted by the grantee pursuant to this Section 13 in an amount and/or concentration beyond the minimum acceptable levels established by current applicable government authorities, or if grantee is unwilling to accept the environmental condition of the easement as a result of such tests or assessments, grantors and grantees' sole and exclusive remedy shall be to terminate this agreement and refund the deposit to the grantee. So if there are environmental concerns that come up with this, we are covered in that. It will be null and void, and they will refund us the deposit. And
But that's subject to you doing an environmental study prior to closing and advising them that
correct,
that's unacceptable.
correct, which the railroad has offered to do for us with a local company, Patriot Engineering. Terry Monis reviewed the agreement. I mean, there are several things that me and him both went through back and forth with Indiana Railroad. Railroad contracts are generally one-sided to the railroad because they are the railroad. So we, try to get the things in there the best we can to cover the county in any lawsuits or anything going forward. So then we make sure we are covered. So we are doing our due diligence to try to make sure everything is covered and make sure that we do taking these things into consideration, because that's the last thing we want as well. We don't want to, absolve the county in any kind of legal action or anything in the future.
On the June 9th deadline, the question that Councilwoman Wilson had asked, I believe that came from a different outside attorney. Where's Indiana Railroad on the June 9th deadline? I thought that was from the long name that you read earlier.
That is basically has to do with the docket and when it's a year time frame, I believe, with the docket. And since it was served June 9th, 2021, they want some resolution of that docket by June 9th, 2022.
Okay, 2022. Okay. Thank you.
This one document, though, said that one of the potential things was that it could be renegotiated. And according to Commissioner Kearns last week, the railroad seems to be pretty hard-nosed on their decision that if this is not done, then they're going to sell off the property and all this. So it doesn't seem like the railroad is very amenable to any changes. And I don't feel comfortable with just, okay, we've got a verbal that they're going to do this. I would want it in writing. I want it solid that they're going to hold us harmless and that we're not going to be sued or can't be sued, that the railroad's going to take over the responsibility with that. I want things ironed out better. They're just not. Things are just too much up in the air right now.
Mr. Modis, from what you've seen so far, the information you've been presented, what is your position on what comes of the property if the county does not enter into this agreement with the railroad? I know there's been some discussion that it would revert back to the landowners adjacent to the railroad. Do you have any findings on that?
There's a number of remedies. I mean, this is a very unusual situation as far as who's in charge, what law governs, and Bob would agree with that. We've both been looking at things together, trying to figure it out. But the Surface Transportation Board controls this because the Indiana Railroad Company is an interstate railroad, and their jurisdiction lies solely under the Surface Transportation Board. And so, like you guys may know, federal law always preempts state law. Well, in this case, the Surface Transportation Board preempts federal and state law, which is a very weird scenario. And so what we have is that the Surface Transportation Board made a ruling, and the ruling states that they can go ahead, and I'll get to your question
No.
here. I'm kind of taking you there so you understand.
Absolutely.
It says at the end of that order, because they had to approve this, if an agreement for interim trail use rail banking is reached by June 9th, 2022, for the right-of-way, interim trail use rail banking may be implemented. If no agreement is reached, Indiana Railroad may fully abandon the line subject to any outstanding conditions. So it basically goes to them then to decide, the railroad, what they're going to do. Their attorney has given us information and said these were their options. Consummate the abandonment and sell the parcels it owns piecemeal, and those property owners with reversionary interest in the line obtaining their respective parcels. Number 2, not consummate the abandonment and retain the line as a line of railroad. Number 3, consummate a discontinuance of service, which will allow Indiana Railroad to continue the property as a railroad, but will terminate its obligations to provide service over the line until it determines there is future traffic. Or lastly, sell the line to a third party as a line of railroad. So those are their options at this point. And something else interesting that I've just been kind of listening to everybody's comments. I got a stipulation from the federal lawsuit. I showed it to Mr. Effner prior. But basically, there's been a stipulation, and their attorneys referred to this stipulation as follows. The parties agree with respect to the claims listed. The plaintiff owned their respective property on June 9th, 2021, the date of Surface Transportation Board issued the notice of the interim trail. Number 2, the plaintiff's property is immediately adjacent to the railroad right-of-way described in the NITU. Number 3, for that portion of railroad right-of-way adjacent to the plaintiff's property, the railroad acquired an easement for railroad purposes. Accordingly, no threshold title issues remain with respect to these claims. So what their attorney is saying is that, based upon this stipulation, that the railroad's already proven they bought the easement rights, et cetera, and the only thing left to determine with the property owners would be if the railroad has to pay them an additional money or not. So that's kind of where that is. Does that answer your question?
Yes.
Okay.
Thank you.
Thank you.
Are there any other questions?
So one of the stipulations that he said was that it can go back to the property owners. That's one of the, if we don't consummate this, it can be considered abandoned, and it could go back to the property. I understand that the railroad bought some of the property outright from some of the landowners that are adjacent to it, and others have an easement, like he said, for the specific use of a railroad, not necessarily for a trail. And that if it is considered abandoned, it goes back to the landowners.
But, Mr. Effner, did you state earlier that for purposes of the Rails and Trails project, it isn't considered abandonment? Is that
That's-
what
that's
your
correct.
position?
But there's a federal lawsuit in Florida that's still arguing that case,
Those options only come to place if
if we don't.
the county decides not to do this deal.
Yeah. So if we decide not to do it, that's a possibility that it could go back to the landowners. I mean, just, to me, having all of these things in the last essentially 2 to 3 days be brought to the attention of the attorneys, for them to have to come with a knee-jerk response is crazy when it's been known about for a year. That's And the way that the property owners have been treated throughout all this is not right.
Let me, so just something to consider, and I guess it's a question for you, Mr. Effner. If the council was to move forward and approve resolution and the ordinance each. They would not necessarily have to do anything with the additional appropriation. They could either approve it, deny it, or continue to table. Is that correct?
That is correct. I think to the extent that there's not money appropriated, I don't think the commissioners would be able to go forward with the sale unless they've got appropriated money for that purpose. But in answer to your question, yes, you could do the resolution and the ordinance tonight, deal with it, and deal with the appropriation later. Obviously, you know, I presumably the commissioners would need that to be done, unless they were able to get an extension, that would need to be done before June 9th, I believe.
The order I got doesn't talk about an extension. I don't know if that's possible. Yeah.
I don't either.
I have one more question, I'm sorry.
So, what,
Sorry, I have one more question. The thing that we talked about last week too was that the 390,000 subtracted from the 1.3.164, the balance of that is not sufficient to complete the railroad or the trail as outlined. That was a given from last week. I know that Commissioner Kearns, I have a question for you. I know you've been talking to some of the property owners about fences and barriers and things like that. Do you have a number for how much the fencing that you've talked about and promised is going to cost?
Yeah, I don't recall a promise. I recall that we mentioned that we have offered to consider that. Our engineer, Larry Robbins, did share that if the council does approve the funding to move forward with the acquisition of the easement, we will then partner with the Rose-Hulman Institute Technology students who will work directly with the landowners to figure out what is best.
How many landowners did you talk to in the last week about?
I really
fencing
wish
and
I could
screening?
recall that exact number for you, Ms. Wilson, but I can't.
Is it 3? Is it 10?
Yeah, I don't recall a number.
Okay.
Yep.
Just wondered, because I mean, that would add to the expense that is already way under budget for
Sure, and that's one of the
project.
things that we'll be taking consideration when we apply for the next level trails grants to help fund this project. So yeah, we're going to make sure that we have all of that in place when we do ask for that additional money from the grants.
Okay.
Thanks for asking that.
You're welcome.
Yep, anything else?
Nope, I'm
Okay.
good.
when it comes to funding, do we feel as though ARPA money will qualify for at least a portion of this?
I gave you all a copy of the final rule that we got in January 2022. I have now touched base with 3 federal legislators, also our local government relations people. With this revenue loss, you can really do any normal county function. But the problem is, Vigo County is not in the leasing business. It's not a county function to me. To federal legislators, it's not a county function. And to our local government people here locally and attorneys, this isn't a normal function. The best way to move forward would be to purchase the lease with edit, and in the future, if the rules get more lenient with ARPA, or, you know, we have a very good explanation that is taken by the federal government, we could reimburse edit the $390,000, if so. If not, will be $390,000 from edit, moving forward with the construction of the trail, asphalt, things of that nature. That is normal, everyday county government. We can afford to use ARPA money to do that. But to purchase a lease, I have not had one federal legislator say that's a good idea.
I would agree with federal legislators.
So the lease, no, but construction of the trail?
Yes, yes, sir. Yep.
So that would be asphalt, underlay, fencing, things like that?
The most important things we would probably tackle first would be the roads. Where the rail goes through right now, they're in complete disrepair. So I think we would do that first, and then start the work on the trail after we get with Rose-Hulman and get some design work done.
Thank you.
Excuse me, Councilman Loudermilk. The one caveat to that is that if they do get grant funding for that, for the trail, and it's federal grant, they cannot use ARPA as a match.
Councilwoman Thies?
What about state money?
State money's fine. If it's
Okay,
straight
'cause-
grant, is not, and it cannot be a pass-through from the federal government to the state.
Right.
So
Okay,
if it originates from federal, it's, no.
I can't, okay. Thank you.
Councilman Norris?
President Loudermilk, fellow council members and members that are here this evening, I think that this is a hard choice for everybody on both sides. I think there's a lot of people who are looking at it from the health benefits. I think there's a huge impact on that. I think there's an impact of bringing places and things to do when you come to town. Now, on the flip side of that, I also understand where the property owners are coming from when they say that's going to cut through where they hunt, where they fish, where they pick mushrooms, for whatever you want to say. So I understand both sides. This by no means has been an easy thing to think about, and I see both sides of it. And honestly, I don't know which way is the right way or the wrong way to make it happen. My hope would be is that we could bring something like a trail to it, and that would help with exercise and health, but at the same time, I hope that the landowners that it affects would see the benefits behind it in the long run. Whether or not that would be true and that's what would happen, that's all up to them. So, that's just my statement on it. It's not an easy decision to make, so.
Thank you. I would echo some of that same sentiment. I think this has probably been since the jail project that we wrestled with for a couple of years, this has probably been the most, had the most fanfare and been the most contentious project that we've heard as a council since then. And, I look in this room and it's divided down the middle as we can see, those for and those against. I think, as was stated earlier, some people are going to be happy and some people aren't going to be so happy with whatever this is reached here. And I'm looking out here, there's people that myself and Councilman Norris are both neighbors with, and some of them can be satisfied and others not so satisfied. But this is a tough one for sure, and I don't think anybody's taking it lightly. There are a lot of items presented to us here recently, so I understand we have a deadline. I understand there is a lot of new information that's came to light here recently, so this is a challenge for sure. We have delayed this a month, and I think that was a necessary thing to do based upon what happened last month and some of the notice that had gone out to the landowners in the area. But I don't know if the council has the appetite to do that again. We do have a June 9th deadline as to where the commissioners are at with the tentative agreement with the railroad. I guess I see some angst on some faces here on the council. I think we have a couple options before us. We can call for a vote, call for a motion and a vote, and it either goes through or it doesn't. Again, I think it's fair to say, and Mr. Effner agreed as much, in theory, we could, this all kind of goes as one package, right? You have the resolution, you have an ordinance, and you have an additional appropriations, 3 separate votes. But in theory, resolution, ordinance could go through, and then if the council as a whole felt like they needed more time or more information to digest what has come before us the last couple of days, I guess in theory, we could hold off on the additional appropriation. I'm not suggesting that, I'm just laying out options because I can see the angst on faces on the council. In theory, we could presumably still get a vote in for the additional appropriation prior to the June 9th meeting. The only reason to do that is to get better understanding of the material we have before us. Where that's going to come from and who's going to enlighten us, I can't speak to that. But again, I'm just giving options here. Now, that could come in the form of a meeting could come in the form of a special call, or I believe since we've already heard this, had first reading and heard it, I would think that we could vote on it in a sunshine meeting, unless I'm incorrect, Mr. Effner. Is that a possibility? Or would it require a special call?
I think according to the rules, there wouldn't be a vote at the sunshine meeting. You might have to suspend the rules. Have to review that.
So you best handled on a special call then.
I would think so.
So those are just items for thought. Anybody has any comments about that? Please state so now. Councilwoman Thede.
I would like, and this isn't me putting a motion forward, but I'd like for us to look at the resolution and ordinance and, take care of that part of it and then gather information. I've sat and watched other projects be developed and things, in the process of what, like the Rose students and others would go through. Kind of, Commissioner Schweitzer talked about, the priority of the crossings where the road was. Those are all, different parts of it that we can address later. I think the urgency is more in the first part, which is the resolution and ordinance.
Thank you. Councilman Thompson?
Mr. Effner, in your opinion, do we still need to add the seller shall warn a title of easement to the resolution? Sounds like the environmental part was taken care of by Mr. Rob.
I would typically recommend that to a buyer, that they're buying something, be a warranty of title. Now, basically, that just says that they're responsible if there is title.
Good point.
I don't know what room there is for negotiation. Like I said, that's one of the things. The other thing was that they be responsible for any existing claims and lawsuits.
So I'm understanding correctly, he's saying that you would advise that the wording be changed to include that, incorporate that. So the resolution as it's written here, not acceptable.
Mr. Effner, could we request title insurance on that?
Well, I'm not sure if title, that's a possibility, particularly in regard to the title. Yeah, I think, but that's typically your title insurance is only going to cover the purchase price, of course. The other thing is that per the agreement that we agree to hold them harmless from any claims of title on things, and including the attorney fees and such. So, that doesn't protect us from that necessarily.
So the resolution in tonight and the ordinance, Council President Loudermilk, is that for the $390,000?
The resolution is just expressing interest in the purchase on a non-exclusive surface easement. So a resolution outlines the area, the length. Names it as the Riley Spur, and then discusses the commissioners are authorized to appoint 2 appraisers for fair market value purposes. So then, if you look at the ordinance, that's where it discusses a price not to exceed the average of 2 appraisals or $250,000, whichever is less. I don't think there's any discussion about the additional 140 until you get to the additional appropriation. Councilman Thacker, did you have something?
I agree with you that in the ordinance it says 250, not that, it doesn't talk about the 140 till we get in the agreement.
Right.
And
that's what
I
understood
agree
as
that
well.
it, and we don't have that appropriation on the agenda. It's not until we get down to ordinance related to appropriations,
Yeah,
correct?
later on,
Yeah.
right.
That's the way I understood it as well. Yeah, I thought that's what you were getting at. And then, it does talk of the title search in the agreement, but it does say that you still accept as is, where is, all false conditions.
Councilman Wilson?
I think I would like to make a motion to table this until we get additional clarification and additional assurances, have the resolution redone, rewritten to include that the railroad will hold us harmless, have some verbiage along those lines. There's, again, too many issues. And if the railroad does abandon, it does allow for some of the property owners to sue to be able to get their property back. And I think it's just, the hold harmless part needs to be included in this resolution.
Just for clarification, the things that I recommended are things that I would recommend to any buyer. Now, this may be a unique situation that doesn't necessarily call for that, and that's really up to the council to determine how far they want to go with the terms and conditions.
I don't want to be sued. I guess I need to withdraw the motion. I guess we're not.
Mr. Effner and I discussed some of the things with regard to title, and the way the railroad normally does these things, these have all been discussed with Larry, myself, and the railroad, is they won't guarantee anything, but they give us the right to check it all out, get title insurance, have it all reviewed, so we're confident before we finalize this. So that's what this agreement does. So just wanted to make sure that's clear, just like the environmental part. Same thing, they can check out the environmental. If there's a problem, then the deal's off. Same thing with the title. That's just the way they do things. And like I say, they take the position that they aren't under the jurisdiction of federal law or state law. So this is the way they operate these trails.
Thank you.
Okay. I'm going to withdraw that motion.
Withdraw your motion?
Yeah, I guess because it's,
She withdrew her motion.
I'll withdraw that.
I'm sorry.
withdraw that motion.
At this time, I would make a motion that we approve a motion for the resolution for the Riley Spur for the county council expressing the interest to purchase the non-exclusive surface easement.
I would like to second it.
So we have a motion on the floor by Councilman Thacker to approve. Second by Councilwoman Thies. Any questions or comments from council? Here's there are none. Ask for roll call vote, please.
Councilperson Thacker,
Aye.
Councilperson Wager,
Aye.
Councilperson Thies,
Aye.
Councilperson Norris,
Aye.
Councilperson Wilson,
No.
Councilperson Thompson,
Aye.
and Councilperson Loudermilk.
Aye. Motion carries. Now have before us ROC 2022-15, ordinance 2022-01, Commissioners Ordinance authorizing acquisition of non-exclusive surface easement known as the Riley Spur. So again, as stated earlier, this outlines what the request is for. We're allowed to move forward with this since we passed the resolution 2022-06. And it authorizes the commissioners to purchase the non-exclusive service easement known as the Riley Spur for a price not to exceed the average of 2 appraisals or $250,000, whichever is less. Any questions or comments about the ordinance?
I'll make a comment, if I can, that my comment on this is, our action on this is just for the 250. If we're not saying right now that we're going to spend the 1.3, we're not looking to raise taxes, we're addressing the opportunity that we have with Indiana Railroad at this time to acquire the easement. Then what projects we do, as well as the $140,000 for appropriation for removing the ties, all will have to come back to the commissioners, and I plan on being right there to hold the commissioners accountable to what they're bringing to us, to what we're going to get out of it. So, as I see this, we're looking at the action on just the $250,000 for the resolution that we just passed.
That is correct.
Okay.
Yes.
No.
No, it's not appropriation.
Appropriation, but we're setting our ordinance. Thank you.
So it's the maximum amount, 250,000, or the average of 2 appraisals, whichever is less. So 250 is the ceiling. Okay? Everyone clear on that? Any additional comments? Any questions about the ordinance? If there is not, be willing to hear a motion at this time.
I'll make a motion to approve ordinance 2022-01.
Second.
Motion on the floor to approve by Councilman Thompson, a second by Councilman Thacker. Todd version. Any questions or comments from council? Having none, ask for roll call vote, please.
Councilperson Thacker,
Aye.
Councilperson Wager,
Aye.
Councilperson Thies,
Aye.
Councilperson Norris,
Aye.
Councilperson Wilson,
No.
Councilperson Thompson,
Aye.
Councilperson Loudermilk.
Aye. Motion carries.
No, these got pulled.
Moving on, ordinances relating to appropriations. We have the next 3 items on the agenda. Salary ordinance 2022-14, ROC 2022-22, VO County Clerk. Salary ordinance 2022-15, ROC 2022-22, VO County Clerk. Additional appropriation 2022-18, ROC 2022-22, Vigo County Clerk, were all withdrawn today by the clerk's office. Moving on, we have before us Additional appropriation ordinance 2022-11, ROC 2022-15, edit. You'll see next, additional appropriation ordinance 2022-12, ROC 2022-15, American Rescue Plan. I think for purposes of this, from what we've been told, the only option that applies is the first of the two, which would be edit, unless something has changed last heard. Been pretty fluid, but edit is the option. Any questions or comments from council?
I just have one comment.
And I just want to make sure everybody's aware that the ask on here is $1.316 million. So before any motions are made, or before we do anything, everybody needs to recognize what that number is.
That's kind of what I had a question about, because I'm not
So
in agreement with
Just to
approving
be-
that amount.
Just to be clear, the ask from the commissioners now is $250,000 for the lease and $140,000 for tire movement, correct?
So it needs to be amended for that.
Councilman Thacker?
If it be appropriate, I'd like to offer an amendment motion of the appropriation.
And is that for, state the ordinance that you'd like to do that for?
Edit, yeah, of this additional appropriation ordinance for, under the edit option one, from 1.31660 to 300,000.
So motion to amend additional appropriation ordinance 2022-1, 1. And that is edit to the 390,000. Any questions about that? Council?
I just want to make sure that that would cover the initial moving forward. Okay, is that, okay, thank you.
Second.
Motion on the floor to amend by Councilman Thacker, second by Councilman Wade. Any questions or comments from council? Ask for roll call vote, please.
Councilperson Thacker,
Aye.
Councilperson Weger,
Aye.
Councilperson Thies,
Aye.
Councilperson Norris,
Aye.
Councilperson Wilson,
Nay.
Councilperson Thompson,
Aye.
Councilperson Loudermilk.
Aye. Motion carries. So now we need a motion to approve the amended ordinance as presented.
I'd like to make a motion that we table it until we, and we, with the stipulation that we can call a special meeting before June 9th if necessary, while we hash out and get more information. So I'd like to table it.
So there's a motion on the floor to table the amended additional appropriation ordinance. So we have a motion on the floor to table by Councilwoman Wilson. Is there a second?
This can be done if we decide to move forward, President Loudermilk. We have time that we could call it, do a special call. Is that correct?
Yes. How much notice do we have to give for a special call?
48 hours.
Just 48 business hours?
Now, I would probably recommend that, since it's an appropriation, I would probably recommend that you table it to a date certain.
Date certain. Table it to a date certain.
We choose a designated date.
okay, to be able to have enough time to have enough time to do more research and still have time for the June 9th date. I'd like to table it until, how about June 1st?
I need to know what additional information is needed because other than a meeting, I have not had any conversation with Ms. Wilson. She's been very critical of this, but I need to know what you guys need to get you to a point of voting for the next meeting.
I need to know that the railroad is going to hold us harmless from any lawsuits, potential lawsuits, in writing.
Is that it?
And I'm still concerned about the property owners' rights in all of this. Okay, I'd like to change the date to May 31st instead of June 1st. Need this many people here to forget. Okay, I'd like to table this until May 31st to make our decision then.
Regular time.
At 5 PM, yes, I'm sorry.
So there's a motion on the floor to table additional appropriation ordinance 2022-11 until May 31st at 5 PM on Tuesday.
Okay, it's a Tuesday after Memorial.
Any questions, comments from council?
No second.
Is everybody good with that date?
I'm not, I'm gone.
We have a motion on the floor.
I'll second.
There's a second. Any questions or comments from council before we have roll call vote? Having none, I'd ask for roll call vote, please.
Councilperson Thacker,
Nay.
Councilperson Wager,
Nay.
Councilperson Thies,
Nay.
Councilperson Norris,
Aye.
Councilperson Wilson,
Aye.
Councilperson Thompson,
Aye.
Councilperson Loudermilk.
Aye. So we have a special call, May 31st, 5 PM, council chambers. We will have, I presume, the necessary advertising requirements in place,
Yeah.
whatever those may
So we just,
need to look like. Commissioner Kearns?
Thank you for your vote and the request to table. What we need from you is, if you could, each council member that has concerns, please send us something in writing within the next week so that we can address them formally and make sure that it is done. We want to make sure that we answer all your questions, as Commissioner Schweitzer alluded to. I will be missing that meeting due to a scheduled vacation with my daughter and wife, but I will answer whatever I can directly to you by email if they're sent to us timely. Thank you.
Thank you. Any other comments from council? Moving on resolutions, there are none. Resolutions relating to fiscal policies of the council. There are none.
Mr. President, can
Mr.
we
Efner.
formally have appropriation ordinance 2022-12 withdrawn?
I apologize, yes.
So do we need to act on having that withdrawn?
Well, I think the commissioners can withdraw it if they would.
Yeah.
The ARPA.
Yeah, we'll withdraw that, or ordinance.
So additional appropriation ordinance 2022-12 ROC 2022-15 American Rescue Plan is withdrawn by the Commissioner's Office. Honorary resolutions, there are none. Resolutions relating to fiscal policies of the council, there are none. There are no appointments. And with that, I would entertain a motion to adjourn.
So moved.
Motion to adjourn by Councilman Wilson, second by Councilman Thacker. All those in favor signify by saying aye.
Aye.
Meeting adjourned.